And you also agree that he was mentally ill at the time of the offenses. All right, Mr. Burke, is that you?
Yes.
Okay. This is in the matter of people of the state of Michigan versus Joshua Jordan Burke. We have 3 files, 24-21878FH, 24-21879FH, and 24-21880FH. I have Allison Arnold appearing on behalf of the people, and I have Katerina Dumont appearing on behalf of Mr. Burke. This is the date and time scheduled for a competency hearing in this matter. I'm actually gonna sit down now. So hold on just a second. Let me get this. All right, so I have received a copy of, well, that's a different one. I have received a copy of a report dated August 12 of 2025, signed by Aaron Serezny, licensed psychologist, consulting forensic examiner. And you received that, Ms. Arnold?
I did.
Ms. Dumont?
Yes, Your Honor.
Okay, excellent. I've also received People's Exhibit 1, which is, well, they're all People's Exhibit 1 for each file. So I have People's Exhibit 1 on each file, which is a felony information. Hold on, let me get back there. And a copy of a police report for each file. You received those, Ms. Dumont?
Yes, Your Honor.
Okay, very good. So, Ms. Arnold, did people stipulate, have we already placed competency on the record?
He is, no, I don't believe.
Okay, so Ms. Arnold, do you stipulate to entry of the report dated August 12 of 25 regarding competence to stand trial?
We do, Your Honor.
Ms. Dumont, do you stipulate to entry of that report as well?
Yes, Your Honor.
Okay, all right. Can I review that report then?
Yes, please.
All right, and then make the findings on that report. Okay, so Mr. Burke was evaluated on August 12 of 2025. He is a 33-year-old man born on October 15. He was charged with home invasion, first degree, second degree arson, assault with a dangerous weapon, jail's possession of a weapon, and assault of a prison employee, and 3 counts of police officer assaulting, resisting, and obstructing. On the 3 files that he is currently before us was a request by the defense for an examination regarding competency, and Mr. Burke was cooperatively engaged in the evaluation according to Dr. Serezny. There was no behavior indicative of an intellectual disability or other cognitive, psychological, or psychiatric issues that impeded his adjudicative capacities. In the doctor's opinion, Mr. Burke was aware of the accusations against him, how they arose, and considered his defense options with reasonable expectations. Mr. Burke understood how the court works, the role of primary legal counsel, his defense options, possible outcomes, and clearly was able to voice his preferences. And Dr. Serezny found that in their opinion, Mr. Burke was able to understand the nature and the object of the proceedings against him and rationally assist in his defense. Therefore, they opine that he is competent to stand trial. So the court does find that Mr. Burke is competent to stand trial. Correct?
Yes, Your Honor. Does the court have orders for all 3 files? I know the one was prepared in my file, and
I don't have the orders, but I'm assuming I will get them.
Yeah, actually, I can email them right now. It'll take just a second because I have to pull up Mr. Sneed's file. Okay. Hang on. Okay, I sent one for file 880.
Are you sending those to Miss Adams or?
I am.
Okay. So Miss Adams and Miss Arnold will be sending the orders, one for each file on, Mr. Burke will need
Okay.
3 copies of each one to sign. So we'll need 4 total. Of each one.
Okay, there's 879.
You can approach Ms. Walsh. No. And see if we do all right, so I'm gonna pause everybody for a second. Mr. Sneed and Mr. Glazier. So Mr. Clark, why don't you come back up to the podium? Mr. Clark. Okay. All right, so we're back with Mr. Burke. So was there a criminal responsibility report?
There was, Your Honor, that found that Mr. Burke is not criminally responsible in all 3 files. It's my understanding he wishes to enter a no contest plea to being not guilty by reason of insanity in all 3 files. And I do have copies of settled record in each file for the court, which would contain exhibit number 1, which is the felony information for each file. Exhibit number 2 in each file would be the police report, and exhibit number 3 would be the criminal responsibility report dated January 27, 2025, also authored by Aaron Serezny, of licensed psychologist from the Center for Forensic Psychiatry. And I believe Ms. Dumont will stipulate to the entry of all those exhibits to support the plea.
Is that correct, Ms. Demond?
That's correct, Your Honor. And I did meet with Mr. Burke at the Lenawee County Jail, and I advised him of
Have
the
all those.
NGR.
But the original exhibit stickers.
Are those original exhibits?
Yeah.
Okay. Ms. Fay, do you want these? Okay,
Thank you.
I'm gonna rotate around. All right, excellent. So Mr. Burke, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so I'm gonna need you to speak up a little bit louder for me. Can you repeat your response again?
Yes.
All right, excellent. Can you state your full name for the record?
Joshua Jordan Burke.
Okay, so, all right, so Ms. Demont, your client is today going to enter a plea of no contest.
Correct, Your Honor. That's what we
And then
discussed.
there will be a finding of not guilty by reason of insanity, correct?
Yes, he would be entering no contest plea to that.
Okay. All right. So, Mr. Burke, you've had an opportunity to speak with Ms. Demont. She stated she came and saw you and you've had time to speak with her. Is that correct?
Yes.
All right. Are you satisfied with Ms. Demont as your attorney and the advice that she has given you?
Yes, so far.
All right. Now you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest? And I think we phrase it to a plea of not guilty by reason of insanity on each of these files. And which counts is he going to be pleading to?
There's all counts in the file.
All counts, but no habitual offender?
No.
No habitual offender. So that would be count 1 and 2. Count 1, 2, and 3. Let me look, hold on, and count 1, 2, 3. So, all right. So, Mr. Burke, do you understand that on file number 24-21879FH, you're going to be pleading no contest to a plea of not guilty by a reason of insanity to count 1, jail, possession of weapons in, which carries a maximum penalty of up to 5 years in prison and or a $1,000 fine. Count 2, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine. The habitual offender fourth offense notice would be dismissed. On file number 24-21878FH, you'll be entering a plea of no contest to a not guilty by reason of insanity to count 1, home invasion first degree, which carries a maximum penalty of up to 20 years in prison and or a $5,000 fine. Count 2, second degree arson, which carries a maximum penalty of up to 20 years in prison and $20,000 or more restitution. And count 3, assault with a dangerous weapon, felonious assault, which carries a maximum penalty of up to 4 years in prison. And then on file number 24-21880, you'll be entering a plea of no contest to a not guilty by reason of insanity to count 1, police officer assaulting, resisting, and obstructing. Count 2, police officer assaulting, resisting, and obstructing. And count 3, police officer assaulting, resisting, and obstructing, all of which carry a maximum penalty of up to 2 years in prison. So do you understand, and is that your intention to plead no contest to a not guilty by reason of insanity on each of those files?
Yes.
Okay. And again, you're satisfied with Ms. Demont as your attorney and the advice that she's given you?
Yes.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Arnold?
That's correct.
In terms of what will happen with the forensic center?
Yes, Your Honor, and I'm happy to put the factual basis on all the counts too, just so you know.
Yeah, okay. So you understand, and the process for this would be, once the plea is entered, it would be processed through the forensic center for the state of Michigan. Is that correct, Ms. Arnold?
Yes, Your Honor.
So we have no determination, Mr. Burke, on how long you would be placed with the Department of Corrections at the forensic center, or what the outcome of that placement in the forensic center would be. Do you understand that, Mr. Burke? That would be up to the staff of the Center for Forensic Psychiatry. Do you understand that?
Yes.
Okay. Anything to add to that, Ms. Arnold?
No, thank you.
And Ms. Dumont, anything to add?
No, Your Honor.
So this court has made no promises to anybody about what will happen there, because it would be under the authority of the Center for Forensic Psychiatry. Do you understand that, Mr. Burke?
Yes.
So if a no contest plea to not guilty by reason of insanity is accepted, there will be no trial. This means that you'll be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Mr. Burke, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that, Mr. Burke?
Yeah.
Do you understand that any appeal from the conviction and sentence? What?
You said no.
Oh, do you understand that? If you had gone to trial, you would have had an automatic right to appeal to the Court of Appeals, but by entering a plea, you don't have that automatic right. Do you understand that, Mr. Burke?
Yes, I said yes.
Oh, okay. I thought you did. Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
Do you understand that if the plea is accepted and you engage in any misconduct, this doesn't really apply to you, but do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310, between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. And Ms. Adams, can we make sure the jail gets a signed copy of the advice of rights from him? Mr. Burke, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions, Mr. Burke, about the rights that I've given to you?
No, Your Honor, I do not.
Okay, so I think it would be phrased, Mr. Burke, so you're going to be entering a no contest plea to not guilty by reason of insanity. So I think your response on this one would just be either, well, no contest, if that's what you wish to do, okay?
Thank you.
Okay, so how do you wish to plead to the charges that on or about February, and this is going to be file number 24-218788FH. How do you wish to, let me make sure I got all these right. Okay, on file number 24-218788FH, how do you wish to plead to the charge that on or about January 11 of 2023 in Madison Township in the county of Lenawee, that you did commit the offense of home invasion first degree? No contest to, but
No.
not guilty by reason of insanity?
Yes,
Okay, and how do you plead to count 2 on that same date, time, and venue to second degree arson?
same.
Not guilty by reason, or no contest to not guilty by reason of insanity, is that correct?
Yes,
Okay, and then on count 3, assault with a dangerous weapon for that same date, time, and venue. How do you plead on that one? Not guilty by, no contest to not guilty by reason of insanity?
yes,
Okay, I'm sorry, that's just a mouthful. I apologize. All right, and then we're gonna move
I'm good.
on to file number 24-21879FH. So Mr. Burke, how do you plead to the charge that on or about February 7 of 2023 in the city of Adrian, in the county of Lenawee, that you did commit the offense of jail's possession of a weapon in, do you wish to plead no contest to not guilty by reason of insanity on that file?
yes,
And then on count 2, assault of a prison employee, do you wish to plead no contest to not guilty by reason of insanity on that file?
yes,
All right, and let's move on to file number 24-21880FH. Mr. Burke, on that file, how do you wish to plead to the charge that on or about December 28 of 2023 in Dover Township in the county of Lenawee, that you did commit the offense under count 1, police officer assaulting, resisting, and obstructing? How do you wish to plead to that? Do you wish to plead no contest to not guilty by reason of insanity?
yes,
Okay, and on count 2, police officer assaulting, resisting, and obstructing, how do you wish to plead to that one? Do you wish to plead to no contest to not guilty by reason of insanity?
yes,
And then on count 3, the same charge, police officer assaulting, resisting, and obstructing. How do you wish to plead to that charge? Is that also a no contest to not guilty by reason of insanity?
yes,
Now, Mr. Burke, you understand your options were on all of these to plead guilty, not guilty, or the no contest to not guilty by reason of insanity. Is that correct?
yes,
And on all of these counts, on all 3 files, your choice was to plead no contest to not guilty by reason of insanity.
yes,
And Mr. Mott, was that due to mental illness, lack of memory?
Mental illness and lack of memory.
Okay. And is that correct, Ms.
Yes.
Arnold? Okay. So, has anyone made any threats or promises to you to induce you to plead no contest to not guilty by reason of insanity on any of these files, Mr. Burke?
no, they haven't.
All right. Do you understand that if I accept these pleas, you will be giving up any and all claims that your pleas are given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes,
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest to not guilty by reason of insanity. Ms. Arnold
No, Your Honor.
and Ms. Demont.
No, Your Honor.
All right, so Mr. Burke, we touched on this lightly already. Obviously, the authority of what happens to you once you go to the forensic center is within their purview. So your attorney hasn't promised you any particular sentence or estimated how long that term would be or what will happen there, has she?
No.
Okay. And is it your own choice to enter all of these pleas to no contest to not guilty by reason of insanity?
Yes.
Okay, so Ms. Arnold, I have felony information for each file as well as the criminal responsibility report. So do you want me to make findings on the criminal responsibility?
Judge, I can put it all on the record quickly.
Okay.
Rather than contest plea.
Okay.
There was a report authored January 27, 2025 by Arson, who is a doctor of psychology, a licensed psychologist and a consulting forensics examiner there. He spoke with Mr. Burke, spoke with his attorney, reviewed all the police reports as well as several mental health records. He authored a comprehensive report of all his findings relative to all the charged offenses, and his criminal responsibility opinion stated, "It is my opinion Mr. Burke was mentally ill at the time of all three alleged instant offenses. It is also my opinion as a result of his mental illness, he lacks substantial capacity to appreciate the wrongfulness of his conduct and conform his conduct to the requirements of law. It is therefore my opinion Mr. Burke does meet statutory requirements for defense of insanity."
All right, and Ms. Demont, you also received that report?
Yes, I have, Your Honor.
Okay, and you also agree that he was mentally ill at the time of the offenses, and as a result of that, he lacks substantial capacity to appreciate the wrongfulness of his conduct and conform his conduct to the requirements of the law?
Correct.
All right, so the court will find then that he wasn't able to do so and met the statutory requirements for defense of insanity.
And I can put the actual basis for the offenses all on the record too.
Can we start with file number 24-21878?
Yes, starting with that file, there's a police report from the Lenawee County Sheriff's Department, report number 23-0000-372, which is exhibit number 2 of the settled record. According to that report on January 11, 2023 in Madison Township, Lenawee County, state of Michigan, an individual by the name of Marilyn Lopez who lived at her residence in Madison Township was present there. The defendant went to the window of her residence and was looking for a female. There was a brief conversation outside. She asked him to leave. He pulled out a flare gun, broke her window with it, caught her curtains on fire, and entered her home from the window. I believe that supports home invasion first degree in that he did enter a dwelling while she was present, and while entering, present, or exiting did commit second-degree arson. Supports the second-degree arson in that her curtains caught on fire within her living room. So he did willfully or maliciously burn, damage, or destroy by fire a dwelling or its contents, and assault with a dangerous weapon in that she was placed in fear of harm to herself by the flare gun, both from it busting through the window and actually causing the fire.
So he fired it through the window.
He both fired it through the window and broke through the window.
Okay. All right, Ms. Demont, do you agree to that recitation of facts?
I'm satisfied, Your Honor.
Okay, so on file number 24-21878 FH, based upon the facts placed on the record and from the information contained in the police report as provided to both the court and to Ms. Demont, the court finds beyond a reasonable doubt that on January 11 of 2023 in Madison Township in the county of Lenawee, that the defendant did commit the offense listed under count 1, home invasion first degree, that he did use a flare gun to break a window and then enter without permission a dwelling located at 129 Store Street, and then upon entry of that did commit the offense of second-degree arson. That dwelling was lawfully was occupied and the occupant was lawfully present therein. By firing the flare gun, he did cause a fire to start with the curtains and did willfully damage or destroy by fire a dwelling or its contents. So that's count 1 and 2. And then while firing the weapon into the building and in the building, did make an assault upon ML with a dangerous weapon without the intent to commit the crime of murder or to inflict great bodily harm, but it was assaultive in its nature, and therefore the court is satisfied with count 1, 2, and 3, the factual basis, and the court will accept the no contest plea. On that file, has the court complied with MCR 6.302 B, C, and D? Ms. Arnold?
Yes, sir.
And Ms. Dumont?
Yes, Your Honor.
Okay, let's move on to file number 24-21879FH.
This factual basis comes from Lenawee County Sheriff's Department report 23-000-1504, which is People's Exhibit number 2 for part of the settled record. According to that report, on or about February 7th, 2023, in the city of Adrian, Lenawee County, state of Michigan, while the defendant was incarcerated in the Lenawee County Jail, he did possess and was observed by Sergeant Van Wert having a toothbrush that was filed to a sharp point for use as a stabbing tool. While he had that toothbrush, he had a confrontation with Corrections Officer Buford, who was an employee of Lenawee County at the jail while he was there. And during that confrontation, he aggressively pointed his finger at her, threatened to kill her and her family, got close to her, and pulled that toothbrush fashioned as a weapon out. Okay. And that's would support count 1, that he possessed a weapon or something fashioned as a weapon at the jail, and then also committed an assault on COB.
How did he threaten the assault? Did he wave it at her? Did he hit her with it?
He was aggressively pointing his finger at her while he was threatening to kill her and her family, and then he pulled the stabbing tool out of his body.
Mr. Mont, you agree with that recitation?
Satisfied.
Okay. All right. So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on February 7th of 2023 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense under count 1, possession of a weapon in jail, and that he had a toothbrush that had been filed down to create a stabbing tool, and count 2, that coming in contact with CO Buford did make threats at her and then wave that tool or stabbing tool at her, which would be deemed assaultive or threat of an assault. So has the court complied, and therefore the court accepts the no contest plea on that file? Has the court complied with the MCR 6.302 B, C, and D? Ms. Arnold?
Yes, Your Honor.
And Mr. Demont?
Yes, Your Honor.
Okay. All right, so let's move on to file number 24-21880FH.
In that file, according to Lenawee County Sheriff's Department report number 23-0015077, which is People's Exhibit number 2 of the settled record for this particular file, on December 28, 2023, in Dover Township, Lenawee County, state of Michigan, deputies from the Lenawee County Sheriff's Office came into contact with the defendant. They knew he had warrants, which they verified, and they attempted to place him under arrest on those valid warrants. Upon arrest, he physically resisted Deputy Jess Petty, Sergeant Conway Linger, and Corporal Keith Forney while they were trying to place him into a patrol car to take him into custody by attempting to pull away, stiffening his body, and kicking.
Okay. All right, would you agree with that recitation, Ms. Demont?
Yes, Your Honor.
So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt on or about December 28 of 2023 in Dover Township in the county of Lenawee, that the defendant did commit the offense listed under count 1, count 2, and count 3 of police officer assaulting, resisting, and obstructing, and that Deputy Conway Linger, Deputy Jess Petty, and Deputy Keith Forney were all present and attempted to take Mr. Burke into custody. They were sheriff's deputy and IDETA sheriff's deputies, and Mr. Burke failed to comply with direct orders from the sheriff's deputies, pulled away, pushed, or attempted to resist his arrest, and therefore the court accepts the no contest plea. Did you do an MC 207 order?
I did not.
Okay, all right, so has the court complied with MCR 6.302 B, C, and D on that file as well, Ms. Dumont?
Yes, Your Honor.
So I accept all the pleas. They've been given understandably, voluntarily, and accurately. The defendant does have full knowledge of his rights. He does have competent counsel. Obviously, this is a case where he pled no contest, not guilty by reason of insanity. Do you wish me to go through the commitment order at this time?
Yes, Your Honor, we would ask
All right.
the court order he be committed to the Center for Forensic
I got it.
Psychiatry.
I got it.
Okay, you got this.
All right.
Okay.
So I'm gonna need you to prepare it, but I've got it. I think
Okay.
your office prepares it, right? I don't know. Okay. So, all right. So Ms. Dumont, I am prepared to go through the commitment order at this time. Are you prepared? Or do you have any objection to that?
No objection, Your Honor. I spoke with Mr. Burke and he would like to essentially be sentenced today,
Okay.
which is
Well, court in this case, say it again. What, Mr.
which
Dumont?
is essentially just being committed to be evaluated at the forensic center. But he's
All right, so in this case, the defendant has pled no contest to not guilty by reason of insanity. So therefore, it is ordered that the defendant is committed to the custody of the Center for Forensic Psychiatry for a period not to exceed 60 days. The center shall thoroughly examine and evaluate the present mental condition of the defendant in order to reach an opinion on whether defendant meets the legally established criteria. Wait, I might have gone on. Hold on. Oh, yeah, no. Whether the defendant has met the legally established criteria of a person requiring treatment or judicial admission within 60 days from the date of this order. The Center for Forensic Psychiatry, I'm all stuffed up, so I can't speak today, shall file a written report with the court, defense counsel, and prosecuting official in accordance with the mental health code. If defendant is subsequently hospitalized as a person requiring treatment or by judicial admission as defined in the mental health code, defendant shall not be discharged or placed on leave without first being evaluated and recommended for discharge or leave by the Center for Forensic Psychiatry. The defendant shall transport the defendant to the Center for Sheriff shall transport the defendant to the Center for Forensic Psychiatry. The clerk of the court shall send to the Forensic Center for Forensic Psychiatry a settled record of facts concerning the offense which defendant was found to have committed but pled no contest to, not acquitted. The clerk of the court shall send to the Michigan State Police a copy of this order. The Michigan State Police shall enter this order into lien in accordance with MCL 769.16B. And I don't think there's anything else we need to add to that order. Okay.
I don't know, in Monroe, we did the other orders, but we didn't do that order, so I'm not real familiar with it.
Okay. I don't know who typically does it here. We don't, I think we do them once a year, maybe. All right.
Yeah, there just aren't that many of them.
Yeah. So Mr. Burke, at some point, you're going to receive contact from the Center for Forensic Psychiatry, and more likely than not, you will be moved to the Forensic Center. I volunteered for years there. It's a nice facility. So I wish you the best of luck. Anything else we need to place on the record, Ms. Arnold?
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.